This podcast is not intended as legal advice. If you're in need of legal services, please contact 602-375-6752 to set up a consultation. You're listening to the official podcast of the Law Office of Libby Banks, Estate Planning, Wills, and Trusts. Your estate planning attorneys in the Phoenix Valley.
Hi there, I'm Libby Banks with the Law Office of Libby Banks.
And I'm Allison Gloss, Libby's new associate attorney.
And we are here with Josh Funkhouser, our favorite business attorney who has his own law firm and specializes just in business law, some real estate matters, and is a great resource for our clients. So thank you, Josh, for being here today.
Yeah, thanks for having me, Libby and Allison. I really appreciate the opportunity to come in and talk with you all.
I thought I'd start with having you just talk a little bit about your firm and what services you offer, and if you want, just a little of your background that makes you the person to go to for business law.
Sure. I have been practicing about in the same area of law for the past 13 years, handling what I amount to contracts. So contracts sort of encompasses business matters. Real estate is all heavily contract related. So I advise businesses on starting up, any changes that they end up making, pre-litigation services where we're dealing with some disputes or questions as to whether we have an issue that are coming up. And essentially, I'm trying to keep business owners from spending $200,000 on litigation and try to help them with their asset protection, help them to make sure that they're avoiding all those arrows that are flying out there in the world of business. And so I started out in Ohio for 5 years. I was actually on an airplane the day after the election in 2016. And so we're at the time this is being recorded, we're right before the next election. So it's kind of interesting that that brought me out to Arizona, and I've been here for 8 years since.
Great. Yeah. You do a lot of proactive planning, which is a lot of what we do with the estate planning too. And, being able to have somebody who can look at a contract and make sure that it's going to protect a client is really valuable. So, yeah.
Absolutely. And I've handled litigation, and I've seen the good, the bad, and the ugly of the disputes and where they end up. So just trying to use that knowledge to put the client in the best position possible to spend a little bit up front to avoid the very expensive problem that can arise.
Great. Well, today we're talking about limited liability companies and planning for a business entity. And one of the first things I want to mention, because I think so many people are not aware or are not taking seriously, and that is the Corporate Transparency Act and the requirements of beneficial owner reporting. Can you talk a little bit about what that is and why LLC owners and other entity owners need to be aware of it?
Sure. This is brand new. This is something that came out in legislation from a few years ago. But now, as of January 1st, 2024, there are these new requirements that any entity, so it could be a corporation, anything registered essentially with in some states, it's called the Secretary of State, that you register your business entity. In Arizona, we have the Corporation Commission. We also have some entities you register with the Secretary of State. But any of those entities, so not necessarily not a revocable trust, but for your estate plan, but other entities, we need to report by the end of this year, anything that was established prior to 2024, you have to register with with FinCEN and file what's called the Beneficial Ownership Information Report. And that means that you identify and provide documentation as to the beneficial owners of these entities. And so a beneficial owner is anybody who exercises substantial control over the management or ownership of that entity. So if you have, and that could be a 25% owner of a limited liability company or a corporation. And so by the end of this year, everybody needs to register and file that beneficial ownership information report. There is some litigation going on where there has been one court that's issued an injunction to enjoin the enforcement of that rule on certain entities. We don't know what the outcome is going to be. If this is going to be found to be unconstitutional, is this really what is going to be the new state of how we're FinCEN and what we have to do for every business entity going forward? But you can take your chances. You have to make your own decision as to whether you're going to comply with this law. If anything has been changed with the entity, ownership has changed during 2024, there is a 90-day window to file that report. So anything prior to 2024, you report before the end of this year, before January 1st, 2025. Any changes during 2024, you need to report within 90 days of that change. And then in 2025, going forward, there is going to be a 30-day window. So any entities set up or changed in 2025 and later, assuming this legislation stays in effect and this rule stays in effect, then you'll have that 30-day period to actually identify the beneficial owners.
What are the penalties for not doing this?
The penalties are heavy. So there are civil penalties and potential criminal penalties. So that's why it's so crucial. We can hope that you don't have to comply with this. However, if it turns out that this is enforceable and the courts are enforcing it, you have a $500 per day penalty for failure to comply.
Oh, per day.
Per day. And there's, I believe, a cap on that, but it's in the thousands of dollars range. It's something to be very concerned about. And as always, any criminal penalties are to be looked at particularly carefully.
Yeah, I've heard about the litigation, and it really only applies to the people who sued and got the injunction. So it doesn't help anybody else out there, just gonna say. And I kept hoping that they would make some decisions, that the appeal would, potentially give us more. But it doesn't look like it, and we won't have that before the end of the year for sure. So I did that for my LLC, and it's pretty simple. But for a company that has, more than one member, managers who maybe are not owners, it can be quite complicated, can't it?
It can, because you can have downstream owners too. You have somebody who's exercising control at another ownership level if this is some subsidiary that is registered. And if you're wondering, is this substantial control? How much voting power do you have in this company? And are you directing anything and going on in this company? I tend to go on the side of just simply registering and identifying those people. There's not a penalty for identifying somebody who may have what could be considered less than substantial control over the entity. And so the safe route is probably to just identify those owners and provide the documentation being requested.
Yeah, be over inclusive.
Correct.
Yeah.
Yep.
Okay. Well, one of the other questions that sometimes comes up, I'll let Allison kind of speak to.
Oh, yeah. So what would be the benefits of setting up an LLC over a corporation, or what are the differences between those two entities?
Sure. And so I think a big misconception that I deal with a lot when I'm talking to potential clients and clients alike is the difference between what your state level authorized entity and then your taxation status. And so when I say you can be set up as an LLC and taxed as a C Corp or an S corporation or a partnership, people say that seems like it's just completely conflicting. Like, how can you be an LLC, but you're also a corporation? Mm-hmm. Well, so at the state level, we can set up various different entities. We can have limited liability companies, partnerships, corporations, nonprofit corporations, and But you can also, so if you select a limited liability company, you can actually have it taxed as an S corporation. And this is a question essentially to ask your tax advisor as to whether that makes sense, because there are certain limitations on how you do that. When it comes to flexibility, though, the LLC tends to be the best option, and that's why you see so many limited liability companies now. Is that just the amount of flexibility? There's not in Arizona and a lot of other states. There isn't an annual filing requirement. You don't have to have corporate minutes every single year and keep your corporate record book that's as extensive as you might have with the corporation. So that's one of the advantages to setting up the limited liability company. And also, if you were to set up at the state level a corporation, there are two levels of taxation. So the corporation can be taxed on its income at the corporate level, and then as soon as it makes any distributions to owners, then those owners are also going to have a taxable event occur, and it report that distribution on their personal income tax return. So limited liability companies tend to be the go-to entity set up for small businesses, people starting out, and they just want to get up and go, have that liability protection, and move forward doing what they do best, which may be plumbing or setting up a HVAC company, becoming a contractor, and the like.
So what I found with a lot of my clients is they maybe created the LLC themselves. They have the articles of organization, which are basically just saying, here's who owns the company, here's who's the manager of the company, and here's who to sue or to serve with a lawsuit. And that's about it. And here's the name of the LLC. What we always encourage them is to think about getting an operating agreement. So can you talk a little bit about what the operating agreement is and the importance of having one?
Sure. The operating agreement is essentially the contract among the owners of the limited liability company. So on a corporation, you may have a shareholder agreement, and you have, but for a limited liability company, it's called an operating agreement. And if you don't have an operating agreement, the default rules are under Arizona statute, the Arizona Limited Liability Company Act. And that's typically how it works across the United States at the various state levels. And so you're just stuck with whatever rules are in place. A lot of those rules don't provide some outlet for how do you get out of this business relationship that you're in. You're just stuck, and now you need to make a decision. Maybe you're deadlocked with a partner, and you don't really have an escape valve. And so but with an operating agreement, you can deviate from those default rules. You can put in place things like, I've had clients have a flip of a coin be the determining factor in a deadlock, or any other ways that you can kind of make sure that this is more suited to the business relationship that you're engaging in. Another benefit of this is if you can, because you don't always need the operating agreement because you don't trust your business partner. Yes, we should have that because we don't know what the business relationship is going to look like in 5 years' time. And so we want to set it up at the beginning to say, all right, here's how we're going to deal with our disputes. Here's who gets to make what decision. But also there are certain situations that you all know, especially with estate planning, where you have somebody who you're not even doing business with who now steps in the shoes of your business partner. And so this could be a spouse in a divorce, and now the divorce judge is deciding, well, those ownership interests are going to the spouse, half of these ownership interests, or whatever the case may be. And now, are you in a business relationship with somebody you never intended to be in with, or a bankruptcy trustee if one of your business partners files bankruptcy, or it could be the estate, the personal representative of an estate, and the business interest just passes. And so you can set up what's called a buy-sell agreement within your operating agreement and sort of deal with that so that you can continue to maintain your control over the business, and you can perhaps buy out this person who's coming in, but you're going to retain 100% control over the company. And so those are some of the benefits of actually using an operating agreement instead of just relying on default rules that are very minimal, incomplete, don't provide the ability to separate from your business partner that you may prefer.
Can you put succession planning in the operating agreement?
Yes, you can. You can set it up so use different like transfer on death designations I've seen done. You can have make provision for, especially if you know what your business succession plan is going to look like, whether that's having heirs or you're at some point you're going to have these owners develop a greater ownership interest, greater control in the company, maybe that. And then if you consult with your tax advisor, that can actually have a lot of tax benefits too. But having those things outlined in a contract, so you're not just relying on, well, Dad told me that I was going to get this at some point, and then now you have 3 siblings who are all wondering, well, how are we going to deal with this business in the future?
Yeah. And what about incapacity planning? So that's part of also what we do with, let's say, for example, somebody who's a solo person. It's just me in my LLC. I have staff, I have a business, but I'm the head, I'm the manager as well as the member. Can an operating agreement be used to provide somebody who's authorized to step in as manager of the LLC?
Yeah, you can make provision for those types of things. I think that's why I love to work with your office and to make sure that the client actually has an estate plan set up so that we can make sure that maybe the owners are not just the individuals, but if you have a trust in place and make sure that there are healthcare powers of attorney and financial powers of attorney so that these decisions can be made and you're not trying to value a business interest in probate and going through the court battle of that. Maybe it's not necessarily a battle. Even if it's simple, it's going to be expensive. But if you have those documents in place and it's recognized in the operating agreement that the owner is the trustee of the trust rather than just this individual, you can ensure that there's a smooth transition. And okay, if something happens, somebody's incapacitated temporarily, then or permanently, you have somebody who can step in and has the authority to take all action on behalf of that owner, or step in and become the successor trustee of the trust and start acting as that owner, dealing with bank accounts, dealing with transactions that are crucial to the business, because sometimes you don't have a month, sometimes you don't have the 6 months that it could take or longer to deal with a court dispute.
Right. Yeah, absolutely. Yeah, without the right things, we sometimes end up with a conservatorship proceeding, and that doesn't always move as quickly as we need to make sure the business is run and that we, salvage a big value in the estate potentially. So, yeah, definitely. So why do an operating agreement if you're just the only member and the only manager?
Sure. And because it can be fairly simple, and the easiest part about setting up an LLC is going in and registering it with whether it's the Secretary of State or the Corporation Commission. But if you have any plans in the future of adding a new owner, that owner, or you may want to sell the business at some point, and part of that succession planning is making sure all of your contracts are in order. So that one of those is the operating agreement. Okay, so I need to see what the operating agreement provides so that I can see who has the authority to be selling this business. All right, if you can sign an affidavit that says I'm the only owner, the statute now governs this and who's able to do what, and I can simply sell my business. That is one option. I think this isn't as crucial, but it looks less professional if you don't have your documents in place. It could affect the value of the business. More importantly, though, is that if I've seen cases where an LLC gets sued, and our number one reason for setting up the limited liability company is usually asset protection. We want to shield our personal assets from collection. So if the LLC owns equipment and that's it, then if a lawsuit comes along against that LLC, then that is hopefully the extent of what the creditors can reach. And so the creditors can come in, they can take the equipment. Well, at least I have my house. I have the equity in my home, and I'm not personally filing bankruptcy. But if there are allegations, like if you are set up an LLC and it's considered what's referred to as an alter ego, and it's just an extension of yourself, a court might penetrate the limited liability company, find that you're personally liable for the debts of that company. And so now your personal assets are in reach. And if you can show, when I set this up, I kept all of my finances separate. So I was using only company funds for company expenses. The company would receive the payments and revenue, and then I would make distributions to the owner. And I had an operating agreement set up. This is not just some sham that I formed in a second, and really it's just an extension of myself. Your chances, I think, improve in litigation of actually protecting and preserving that liability shield. That is the entire point of handling this. So I think that's probably the most important point. But it also varies case by case, because some people have different aspirations as to how they're going to grow this business, and having the terms set up in your operating agreement to handle that properly are important too.
I feel like most frequently the clients that come into our office have LLCs that are rental properties. And I've seen it sometimes where people will have 4 rental properties. Would you say that having an LLC for each property is best, or can one LLC cover all of those properties? Sure,
that's a common topic that I've dealt with as well, and I've had some clients who say, "Look, I don't want to deal with the complications from having multiple limited liability companies, and so I'm just going to have one LLC own all of those properties." And that's a business decision. It's a risk assessment that a client is going to have to make for themselves. But as long as they're aware that the liability of that limited liability company can reach all of its assets, then they can at least make an informed decision about that. And what I mean by that is, if you have an incident happen at one property that generates liability for the limited liability company, if it owns all 4 properties and they're all
touchable.
Right. And there's equity, they're collectible, then the creditor is going to be looking at what are all of the assets of this person, because a limited liability company is a person. What are these assets that I can go after? Well, there are 4 properties there. Now, if you have LLC 1 own one property, LLC 2, LLC 3, LLC 4, then at least you can compartmentalize that risk and provide the best liability protection that's reasonably available. Then that's typically how the clients will handle it if liability protection is of the major concern, rather than trying to deal with accounting for the different properties.
Okay. I've had 2 clients in the last month ask me if they should put their vehicles in an LLC, and I find that to be a funny question. I don't know who's putting that out into the universe, but what do you think about that?
Well, I think that can be if it's a business vehicle, right, then it likely is the ideal setup. Right. Because if you're using it in business, it's probably going to be better for your insurance, because your insurance is, if it's a commercial policy, it's dealing with company property, and then all of a sudden you've got this vehicle in your personal name, it can cause some confusion potentially with that. And also back to, we want to make sure we're not blurring the lines on is this LLC really an extension of me, or is this separate? And if you can say, okay, there's the company vehicle, it owns its own vehicle and it's titled in its name, then that's the that can help you. So
but if it's your daily driver, then
right, if it's just your daily driver, is this really for business purposes? And I could see a court declining to provide that protection. And if it's like, what is the service that this car is providing? Well, I drive my kids to soccer practice and whatever else in it, and it's probably of minimal value. And so I actually have not set up an entity solely for the purpose of having vehicles in it like that, unless it's company equipment. If it's a motor vehicle, like a truck, then of course that would be a different story.
And so turning some of that asset protection around. What if I, in my personal vehicle, run over somebody, I get sued, and I get a judgment against me? I've got, say, 3 LLCs with my rental properties. I own those LLCs. Can my creditor get to the assets in my LLC?
And that depends to a large extent on your operating agreement. And so if there are mandatory distributions from those limited liability companies to you, then the creditors can essentially step into your shoes. And so they can get what's called a charging order, but there are ways that you can set up the operating agreement so that those distributions are not mandatory that can assist you in asset protection. But generally, those are your assets. And so it is much more at risk. It's if the owner of an asset is liable, then the asset is generally collectible. And so going after limited liability company interests can be very complex and difficult, but there are some strategies that you can use to assist depending on your situation.
Yeah. So that operating agreement then can protect your the assets in the LLC as well if it's written properly. To provide at least a more difficult situation for the creditor to get to those assets.
Right. And I've seen where you have mandatory tax distribution. So because an LLC can generate profits and those profits will be allocated, whether you get a distribution of cash or not, allocated to the owners. And the owners will then have to report that as income on their tax returns, depending how they're taxed. And if you have this, some operating agreements, and this sounds like a good idea, just require that the cash be paid to cover the taxes. Well, what if your tax bill is $20,000 and you have a mandatory distribution, but you have a giant creditor out there? Now that creditor is going to say, you have to pay that money out. You can't retain that cash in the company. It needs to be paid out, and you're not using it for taxes. You're paying it to me instead. And so that's one example of where it can cause some issues that you might not think of.
Yeah. And what we find is a lot of asset protection is just making it so difficult for the creditor to get to what you have that they're very negotiable, that you can work out a deal to pay them less, hopefully, and make them go away, because it's going to be very expensive for them to litigate potentially to do that charging order, finding out that they don't get anything because you're just not going to distribute anything out until they go away.
Right. It's like when you have multiple debtors in a situation, if you have 2 people who are responsible for the debt equally, the creditor is going to find whoever's the easiest to pursue. It's sort of like that analogy of the bear in the woods, and like whoever is the slowest and is the easiest to catch is the one who's going to be at the most risk. So, making it difficult it can definitely assist you from a practical standpoint, because if you're going to spend $100,000 going after 50, what's the point?
Absolutely. Well, I really appreciate you coming. An important part of estate planning for somebody who's a business owner is having a good business attorney in their corner, and also having the right documentation for that business for incapacity planning, asset protection, and what happens to that business on their passing. So we appreciate you being one of our great resources here at our office.
Well, I appreciate the opportunity to come in, and I definitely, the planning process is incomplete if the estate plan is not in order, because if you cannot make decisions because you're just for any reason, you need to have that estate plan in order. And so, I always tell clients that it's essential that you get the trust in order in your powers of attorney and the documents and areas of your expertise.
Thank you for listening to our podcast. I hope you'll join us again. If you want more information about our law firm, you can find us at libbybanks.com or give us a call at 602-375-6752. Thank you.
Thank you for listening to the official podcast of the Law Office of Libby Banks. If you're in need of an estate plan, please reach out to our team by either calling 602-375-6752 or emailing info@libbybanks.com. You can follow us on Instagram and Facebook. Just search the Law Office of Libby Banks. Free consultations apply to new and existing estate plans only. If an estate plan is not completed or was prepared by a third party, revisions will be given at an hourly rate. This has been a T-Door production. Music by Track Tribe.